To make legislation.
Who we elect.
Who the voters elect, and to appropriate money. Yes.
Now, that brings me to you brought up a question in advance of, because I was talking to friends and they were saying, well, ask her about school funding. Mm-hmm. And another question that came up was, what about this business of changing our Constitution so easily? In the state of Ohio, you only need a simple majority. Is that correct?
To change Ohio's Constitution? Mm-hmm. Well, I don't know that that's accurate with a simple majority. It may be. But if you're talking about referendum, like the casinos, for example.
Well, actually, the friends I was talking to were talking about the amendment that made marriage.
Oh, so that was a referendum. So what happens is Ohio's Constitution favors individual liberties. And so Ohio's Constitution, therefore, favors referendum. And so any citizen that has a cause can go out, and if they get, let's say, I may not have the statistic right, but 10% of the percentage of people who voted in the last gubernatorial election to sign a petition, an issue gets on the ballot. So the Defense of Marriage Act got on the ballot. A referendum of the president's health care law got on the ballot. The current referendum on redistricting got on the ballot. So that's how that happened. Casinos are now enshrined in Ohio's Constitution
because of a
referendum. So what happens is then you have, let's take the casinos or DOMA as well, the Defense of Marriage Act. People come in, they spend lots of money. They get people, a majority of people vote, and then it becomes enshrined in our Constitution. That's why every decennial year, every 10 years, we have a proposal for a constitutional convention, which would bring people together, legislators and elected officials, to look at Ohio's Constitution and make recommended changes. That's on the ballot this year. So people have to decide, do we need to reevaluate what's currently in the Constitution or not?
Well, to take that one step further, my friend said, it seems to me that if the United States Constitution has such a harrowing job before it can be changed, why isn't Ohio's Constitution equally difficult? And my answer, I'm not a judge, and I don't sit on the legislature, but my answer was because the people willed it.
The people willed it. To change the United States Constitution, like we found out with giving women the right to vote in 1920, you need 2/3 of the states.
Yes.
And so you have to have 2/3 of the state vote to change the U.S. Constitution. In Ohio, in many matters, Ohio as a frontier state, a state that stood strong against slavery, they vested power in the people. And so Ohio's Constitution actually gives greater rights to people than other state constitutions.
And we're talking the two-leg variety of people right now. We're not talking corporations necessarily.
No, we're talking people.
Okay, so originally the people, human beings, were given extra responsibility and rights in Ohio. And that's what makes our job so important here, that if we don't stand firm in what we do and think about, and I put emphasis on the word think, because some of my friends like to react. They only wake up and look around when they're angry about something, and most times they don't necessarily know exactly what they're angry about.
Think is we always have to be playing the long game. And what I often think about is when Gandhi said, we must be the change we want to see in the world. Think about this. Think about people. The greatest sacrifice any individual can make is to fight for something you may never live to see. So think about how many people gave their life in the cause of ending slavery, in the cause of giving women the right to vote, in the cause of ending segregation. I often use this as an example of, to your point, think. When Plessy versus Ferguson was decided in 1896, separate but equal was the law of the land, the Supreme Court declared. I often use that when people talk about activist court. Well, nowhere in the United States Constitution is separate but equal written, but somehow that became the law of the land. Now, people could have gotten angry. African American people could have gotten angry. They could have marched. They could have burned down things, but that wouldn't have changed anything. What happened after Plessy versus Ferguson? You had W.E.B. Du Bois and the NAACP who said, okay, if this is the law of the land, we're going to pursue a challenge in every state to make them prove that separate is equal. Every state.
That's right.
And so they developed, through thinking, a separate state strategy. And they, with lawyers from the famed Howard University, they took on every state from Missouri to Georgia to Tennessee to Maryland, attacking the separate but equal. It took time. In fact, it took 57 years. But through people like Thurgood Marshall, Charles Hamilton Houston, who was then a member of the NAACP, the dean of Howard University Law School, they raised up a cadre of lawyers. They attacked it on the very rules the country had set up. And so instead of reacting, they were planful. And in the end, they succeeded. We've got to stop being, to your point, reactionary and be thoughtful, strategic thinkers about how to attack problems.
And along that road, that long road that they traveled, thinking at every step, the absurdity of separate but equal became more and more apparent. For example, Fred Gray.
Yes.
Fred Gray was unable, because of Plessy, to attend a law school in his home state of Alabama. But because of Plessy, because of the thoughtful reactions to Plessy, they had to give him an equal education. So they sent him to one of the best law schools in the country, Case Western Reserve University here in Cleveland. And he came here and he got his law degree and went right back, and maybe the third case, I think it was, that he ever had as an attorney was Rosa Parks.
Right.
And so the absurdity of separate but equal became more and more and more apparent until it crumbled.
Dissolved. And so if they had done the other thing that our young people are so want to do, is get angry, get mad, I'm not going to do anything, I'm not going to participate, we'd still have it. You got to be smart. Take the rules, learn them, and then beat people at their own game. You've got to understand what's at stake.
You know, I can't imagine that they weren't angry, but they were not reactionary.
That's exactly right.
You know, you can be planful, feel your emotion, and let that stimulate you to take the next thoughtful step.
That's right. Don't be so angry that you lose perspective. Because what's the Bible said? The race is given not to the swift, but to the strong, those who persevere.
Yes, endurance is the issue. What you just remind me of, and forgive me, I'm a divergent thinker sometimes. I had a conversation, most of the time, my son will tell you. I had a conversation with an attorney who used Sharia law to defend one of the first women who was accused in Nigeria of having unlawful sexual intercourse that resulted in a child. And she had been accused of adultery. And my friend, instead of blasting Sharia law, which is what most people wanted her to do, she studied Sharia law. She's Hausa, and discovered that Sharia law said something like, if you are witness to the moment of conception, then you can find the person guilty. And it struck me that that's so very similar to what Jesus said of the people who were about to stone someone. You know, you'd almost have to have God's eye to be the witness of the moment of conception, and therefore be perfect. And so she used that, and the elders who were the judges in that case had to say she was right. Have you ever had an argument that came before you since you've been a justice on the Supreme Court of Ohio? And I have to say that over and over again because it just gives me chills to say it. Have you ever had a moment when that leap into justice, you felt it was so palpable? Because apparently for her, those judges who were, respected citizens in their community, they had this moment when they went, she's right. She's right.
Aha moment,
The aha. Have you ever had that?
Not as clearly as that, but there are times where somebody is arguing in front of you, and it changes what you thought of a case. They say something that it clicks for you, and you're like, wow, they've got a point. I mean, lawyers always ask me, they say, does oral argument matter? Absolutely. It's one thing to read your arguments on the page, the cold record, but it's something else when you stand there and you respond to questions and you have passion about the facts of your arguments. So yes, I'm very cognizant, as I think my colleagues are. Every decision that we make has an impact on real people. You never lose sight of that, because people have no opportunity of appeal for us, except in a very less than 1% of cases. And so it really is important that we are diligent in what we do, and that we never forget behind this stack of paper are real people who are going to be impacted.